Yes, thank you so much, Priscilla. Good morning to you, and good morning to you, whoever is watching Morning at NTV online, but also on set. Indeed, that is a perfect introduction for Honorable Mike Kazazgluka. I would straight away ask him what he makes of the reintroduction of this amendment bill, UPDF Amendment Bill 2025. Good morning to you, Honorable.
Well, good morning, Mr. Mbide, and good morning to all the viewers of NTV. Both on set and online. Quite obviously, I find it rather disturbing that Cabinet has tabled the UPDF Amendment Bill in the form that it is. When I went to the Supreme Court, to the Constitutional Court back in 2016, I challenged one, the composition, two, the independence of the GCM, and also its establishment, because I was very confident that the GCM was an illegal outfit to the extent that it purported to be a court of judicature. So the Supreme Court, both the Constitutional Court and the Supreme Court, agreed with my position. And so I find it rather disturbing that the amendment bill seeks to reintroduce the same GCM in the same or even worse manner than it was previously. Because one of the issues that the courts looked at was the issue of the independence of the chairman and the panel, not merely the qualifications, that by simply replacing the panel with qualified lawyers, that does not address the issues we raised. How do you guarantee the independence of serving officers who are under the command and control of the Army High Command and the CDF and the Commander-in-Chief? Issues of fairness, fair trials are constitutional matters. So there is no way you can guarantee that any panel, whatever qualification the members may hold, will give a free and fair trial to anybody, whether be it a civilian or a serving military officer who appears before them.
But Honorable, during the hearings of the Supreme Court, I remember some of the issues that came around where the composition, yes, away from the composition, but also the qualifications, that, like you were saying. And now the executive is saying, look, we're going to introduce one who will be heading the GCM, will be at the level of a court judge. And this is one of the demands that we are talking about, that, they're not qualified.
Well, as I said, far away from the mere qualification of being a lawyer, having qualified at LDC and all that, and therefore probably equated at the level of a high court judge, the Supreme Court was clear. And I remember very well in the judgment, while delivering the judgment, the Chief Justice advised government that the High Court, rather that the Supreme Court could be able to appoint judges. Now, by the Supreme Court saying that, it means that it is not enough to merely be a legal person or an advocate at the level of a High Court judge to chair the panel. We look at issues of independence, because while you may be qualified as a lawyer, are you going to dispense justice where you are subject to command and control of the Army High Command? Because anybody, any UPDF soldier, swears an oath to obey the Army High Command and the Commander-in-Chief. So whether you are qualified or not, the fact that you are a serving soldier who still wants promotion and expects promotion and promotion is based on performance in military service, meaning obeying command and control, you will not be in position to dispense justice fairly.
Then what's the spirit of the reintroduction of this amendment bill? What does it speak about the...
Of course, Mr. Museveni and his government have long sought to weaponize the GCM. The GCM was created as a weapon not to dispense justice, but merely to oppress those that do not take his political line. If you look at what it was previously, you would have people putting on red berets appearing before the GCM, and then the gun-wielding thugs appearing before the civil courts. We have cases, for example, here in Tinda where we are. About 3 or 4 months ago, there is a group that shot and killed the brother of the deputy Lord Mayor, Nyanjura Doreen. And that group, using guns, but were produced before a civil court. At KCCA, we have issues of suspected rebel leaders, the Jamiro Mukulos and the others, the Koyeros, who were appearing before the civil courts. But on the contrary, you have Bobby Young, you have all these Nup youth appearing before the GCM. So clearly, the GCM is only a tool for political suppression.
Then if that is the case, what does this talk about the independence of the judiciary? The Supreme Court comes, the highest court in the land comes up and makes a pronouncement. What does it tell about the respect of institutions, judiciary, legislature, and executive? Especially the judiciary. Definitely,
anybody out there should realize that this is a creeping erosion of the separation, of the doctrine of separation of powers. By so doing, Mr. Museveni and his government are clearly on a path that seeks to erode the democratic achievements that we have thus far achieved. This is a clear affront on the powers of the judiciary and the legislature. That is why, to attain this, Mr. Museveni has to buy off legislators to toe his line. Clearly, it is not something in the interest of the people of Uganda, and I want to put Mr. Museveni and his government on notice that we will not accept this. We have challenged it once, and we are definitely going to challenge you again.
You mean after the passing of this amendment bill, or before you?
Of course, we cannot challenge the bill legally until it is passed into law. But of course, we are going to take whatever steps we can to talk to these legislators. You know, we are quite alive to the fact that even a dead clock functions or tells the right time twice a day. So I am hoping that in their deepest hearts of hearts, they find it right to do something for the people of Uganda. We know Mr. Museveni can't walk into an election without his scarecrow, the GCM, because he has only used it to threaten people, to scare people, especially towards an election cycle. So we know he cannot walk into his 2026 election without his scarecrow. But we're going to appeal to members of parliament first to do the right thing. And should they not, then we will proceed to the Constitutional Court to challenge the same.
You know, Honorable Michael Azguluka, this is also coming at, again, like you've said, in a political season. We know 2 presidential candidates have appeared before the General Court Martial before, Robert Kyagulanyi and Dr. Kizza Besigye. Right now, Dr. Kizza Besigye is still in incarceration and is supposed to return on 21st of this month. And he's making 6 months in incarceration. And he would want also to stand maybe on behalf of PFF or the presidency. As we head into the presidential campaigns and the nominations and the polls in 2021, and these 2 key principles in our political doyens are looking on as this amendment is coming up, do you think that this could also be targeting these political actors in a way?
Absolutely, absolutely, without any doubt. As I have earlier stated, Mr. Museveni does not envisage a scenario where he walks into an election without his scarecrow, the GCM, where he seeks to, have a tool that curtails the freedoms of the people of Uganda. As I told you previously, that only political opponents have appeared before the GCM. It has nothing to do with the dispensation of justice to the gun-wielding thugs, as he has written, or as he continues to assert. This is only and only a tool of political suppressions.
You envisage a scenario, a situation of Dr. Kizza Besigye, who is now still in prison, coming back, and then they say that after the passing, maybe if it's passed and endorsed by the presidency, do you think that he may be taken back even before 2026?
Well, I don't think that these applications would be retrospective. He has already been produced before the civil courts, so there is no way they can have another trial relying on the same set of facts, if any. They cannot use the evidence that they used previously, which was quashed by the Supreme Court and taken before the civil courts to be retried in the new GCM. So I don't think that will happen.
But then one of the provisions within this new this amendment bill is if you're found with an ammunition, defined ammunition, within or outside of this country, then you are liable to go to the GCM.
Well,
is this...
That position is very, very unfortunate because in the existing laws of this country, we have sufficient measures to address such. We have, under the Penal Code Act, we have such offenses as unlawful possession of firearms, we have unlawful possession of government stores and other crimes under the Penal Code Act, which can ably address that. So there is absolutely no need for the GCM or the amendments as it is now to address issues that are already addressed.
Thank you. And finally, this bill has already been taken to the Legal and Parliamentary Affairs Committee as well as the Defense Committee. Will you, as Michael Bazgluka, rally other people who are opposed to this bill, go to these committees and also face them? And also, what's the last word on the show for now? Well,
as I have stated earlier, we are going to do whatever is reasonably possible to, one, appeal to the members of Parliament to do the right thing. But of course, that may also include us appearing before the Parliamentary Legal Affairs Committee to give our views. And finally, when that fails, we will go back to the Constitutional Court to adjudicate over the same matter.
Thank you so much, Honorable Michael Bazgluka. He's a former member of Parliament for Nakawa, but I understand that he's back into the trenches and he wants to carry the flag. If PFF is just as a political party in Nakawa East, I know that for a fact. For now, I take you back to studios for more conversations because I know Honorable has other engagements this morning. Thank you so much for being a part of us. Please, Regina, take it over from me.
So much, Stephen Bide. Now we get to have a deeper discussion into the subject matter for the day, examining the UPDF Amendment Bill 2025. And my guests are going to do just that. Of course, when we look back at the Supreme Court's ruling on the 31st of January this year, it delivered a landmark ruling that declared that the trial of civilians in military courts be unlawful, something the President found unsettling and resounding. Now, with members of Parliament having returned from a long long recess, and yesterday being given the opportunity to be presented the UPDF Amendment Bill 2025 being tabled to them with a major perception that they will be able to reintroduce civilian trials in the General Court Martial. Now, the nitty-gritties of the clauses in the proposals is something that we want to dig deeper into. My guests this morning, of course, I do have Councillors Alan Mulindwa and Ronald Wanda that are going to be joining us on this conversation, and also political analyst Simon Mulongo is also going to be giving us his 2 cents on the matter. I'm going to be starting with Councillor Alan Mulindwa. Good morning to you, Councillor.
Good morning.
How are you?
I'm fine. How are you?
Well, we are caught between a rock and a hard place because we are the civilians at the end of the day, and the word civilian has come out so loudly in this particular amendment bill. Talk to us about where you stand and what are your views on this amendment bill.
Basically, in principle, civilians are supposed to be tried in civilian courts. And then those who are in the army or those who are in security forces are supposed to be tried by General Court Martial. That is the principle of law. What they're trying to add is a concept. Concept is someone's idea. That is something outside the law. And there are so many concerns that are coming up, among which that if there is a Constitution of the Republic of Uganda, which gives the High Court unlimited jurisdiction, so the High Court has the powers to try all these capital offences, why will you duplicate the same kind of jurisdiction to the General Court Martial? So basically what we are seeing in this amendment bill of the UPDF is that they're now duplicating the structures of civilian courts. And one of the issues that are being sent out, the principle that they're trying to bring out to meet a concept, they're saying that if you're a civilian, you conspired with somebody who's in the army or an army officer in committing a crime which is has jurisdiction in the General Court Martial or a divisional court or a unit court, you should be tried. And there is somebody on the other side who's the army officer, you should be tried on the other side. Now that is the kind of justification they are giving. Of course, when you listen to that kind of rationale and reasoning, it makes a little bit of sense, because what will happen if it is an army officer who has committed an offense with a civilian and is being tried in a civil court? So will this army officer be brought, because the evidence has to be laid this other side with the co-conspirator or person who aided and abetted? So that's where there has been some kind of gap. We don't know whether this person, if he's an army officer, should be brought to this side, or if it is a civilian, the other court wants him to be part of the trial, should be brought to the other side. That's why they're coming up with this. So to me, I think that should be the issue that should be addressed, and the alarmist that is coming out that civilians are being tried in the General Court Martial. Likewise, also the army officers will come up with the rationale to say that we as army officers should not be tried in civilian courts.
Okay. With that being said, could you draw us some realistic examples of cases that have had civilian plus army officer being tried in the civilian courts and how they ended up?
Of course, when it comes, I'm not really so much a criminal practitioner, but we've had instances where we've seen serious armed robbery, where army officers have staged roadblocks and have been at some point arrested at the police stations, and maybe even the civilians are involved, and the case is ongoing. But at some point, the UPDF has got challenged, because most of them go back to the barracks. So getting these what we call summons or arrest warrants from the courts to get these people, the UPDF has been resistant to some extent, and then this has also frustrated trials in the past. So this is really something which is a reality out there.
Okay. All right. Councillor Wanda, good morning to you. Welcome to Morning at NTV.
Good morning.
And on where you are seated, what are some of, in the proposals that are in this UPDF Amendment Bill 2025, what are some of those clauses that are very contentious from where you are seated?
Thank you so much. From my side, and I'm very certain from majority of Ugandans, is the clause that is trying to create one exceptional cases that should be tried by the General Court Martial, and also trying to replicate Section 117 of the UPDF Act by defining who is subject to military law. We've had an argument, and we still have the same argument, that no civilian should be tried in the General Court Martial for so many reasons, and all the reasons were ably handled in the Supreme Court judgment of Michael Kabaziguruka. But of course, we know the state is so intended with vigor to still try and bring back civilians in that court. It's unfortunate, and we are hoping that our legislators should surely come up to speed on this particular bill, at least not to pass it as is. Of course, there are some good clauses in there which are beneficial to the military, situations where they have created the heads of these particular courts, from the unit to the division and then the General Court Martial, to be people who have gone to law school as a bare minimum. That will help even the soldiers appearing before such tribunals, even for disciplinary related cases. But for criminal matters, we still hold a big argument that the same should be in the civilian courts. And the rationale is very simple. Soldiers or people in forces adhere to command. They listen to command. In a situation where we are having the chairperson or the members of these courts being appointed by the High Command in consultation with the Judicial Service Commission, that is the first fault. For all the courts we have, whether they are special courts, whether they are the ordinary civil courts, we've had people being appointed by the president in his capacity as the head of state, but also following recommendation from the Judicial Service Commission. Now here we are having judicial officers who will be appointed by the High Command and in consultation with the Judicial Service Commission. So what we are not sure of is whether the consultation, whether the feedback from the consultation will be binding, or it will be a by the way to take off something that we did consult with the Judicial Service Commission, and we have appointed so and so. For as long as the appointing authority is still the High Command, there is a problem, because it means that the particular officers who are wielding judicial power will dispense the judicial authority and power in accordance and in respecting what the High Command wants. And that is a very big problem.
All right. Mr. Mulongo, good morning to you. By and large, the intention is to really restructure the military in terms of justice. But at the end of the day, some elements are touching the masses. And the response and the reactions are quite difficult to apprehend. It begs the question, from where you're seated, what are the positives, especially to the masses, and also what are the negatives that we're seeing in this bill that need to be scrutinized a little bit further?
Thank you. I think the intent of governments world over is to ensure good governance, constitutionality, law and order for their countries and citizens. So in this case, we've walked a journey where the military courts were heavily criticized for being so much operating in a manner that's against the Constitution, and this matter has ended up with the courts of law, as you know, and the ruling of the Supreme Court in January. And in the ruling of the Constitution, of the Supreme Court, they provided conditions under which, if such military courts would operate, to fulfill. So what is happening now is really fulfillment of those conditions, some of which colleagues have just mentioned, that we have to restructure these courts, realign them, similar to courts of judicature as we know them, to staff those courts with people who are competent, lawyers, and also in terms of appointment to provide some degree of independence of both the appointment and the tenure of those officers. And they brought in, as my colleague has said, the Judicial Service Commission. This means, well, we can also interrogate what it means by consultation, but I hope also the lawyers, the legislators will make sure it is well defined. But they are into the equation that nobody will just be appointed without Judicial Service Commission being involved. So as such, to me, this brings in streamlining the issues that were contested by those who were opposed to military court martials. And this is good both for the military and for the civilians. Why is it good? Because it now defines clearly who should become party to be tried in military courts. My argument about civilians, if people talk about civilians as if it is en masse about all civilians. It's not just any civilian. Those who want to behave, who support and act as military people. And this is really good for national security, because who is a civilian is a very controversial definition you can have. There are those soldiers who have retired, they are trained, they have skills, they have capabilities that can destabilize a country, they can overthrow governments, and so on. So you cannot just define a civilian per se, because it's like anybody just walking down the street. And then there are those who aid, who provide facilities. We've seen in the history of this country, civilians aiding, supporting military actions that have caused a lot of upheavals. And by nature of their actions, their skills, their knowledge, their capabilities, they are suitable to be tried in a court that are also specialized in understanding those capabilities, those skills, that they can determine whether they are culpable or not. And finally, Madam Moderator, we've seen many civilians taken to military courts and have defeated the state. They have walked out. People have been tried in military courts before, but they came out. So the question of whether fairness or unfairness should be used judiciously, that really if somebody has been to military court before and has even defeated the government and they walked out scot-free, then there must be some degree of fairness there.
All right. Mr. Mulongo, is that to say that the civilian courts are not capable of handling these specialized cases?
Well, the fact is that when it comes to military things, there are some added elements that may have may be tricky to civil courts. And that's why even world over, we have so many other countries that have military courts, including the US. Only that in the US, the civilians cannot be tried under certain circumstances, like under martial law or something like that. But there are other jurisdictions, whether Egypt or Pakistan, there are other democracies that actually also operate similarly. Why do they have to introduce such? Is because of the strict and extreme nature of certain circumstances that may require a certain degree of expertise. I know the land friends will always want to say, yes, but we can do anything. We can educate over medical issues, engineering issues. But you see, military is exceptional in this case, because the military have capacity to change the order of history, and therefore they require that are given special treatment.
Okay, all right. Counsel Wanda, you are one who has, you're in the legal team of a client who is facing this wrath of this law. And if this is really signed, they could be faced with a whole bigger challenge altogether. The contention of, is he civilian or is he not civilian? And from what Mr. Mulongo has shared with us, is that if he's previously a military officer, then the General Court Martial has a leeway in those loopholes. And so how do we get to close those loopholes to ensure that we can have a definitive line when it comes to trying of civilians in the specialized cases, either for civilian courts or they are taken to the martial courts?
Thank you so much. You know, with my senior brother here was explained that there are civilians who have been acquitted, who have walked out of that court. I don't recollect any civilian who has been acquitted, who has been tried and acquitted. Majority of other cases have died a natural death, or they have been tried in the Constitutional Court and have gotten their bail decided, and the cases have never seen light of the day. However, in light to what has been posed to me, is yes, we are facing a challenge, and they are trying to define who is subject to military law, and giving all kind of scenarios, which very unlikely that anyone would escape if the state is intended to try you. They keep on alluding to what we call aiding and abetting a service person in committing a service offense. Now, when it comes to aiding and abetting, it's you've assisted someone in committing an offense. Now the question is to what degree? They are not, we don't know the degree. What they have to do is just get a service officer, have them on the charge sheet as the principal offender, and they'll have you as an aider or abetter. That is very problematic, and that's why our argument is still to the effect that, I mean, if you believe a civilian has committed an offense, let them be tried in the civilian courts. The civilian courts have the capacity to try any offense, but in the event the state thinks that the civilian courts are not competent enough, there are so many options. They can appoint their own from the military to the civilian courts, and they serve in the civilian courts.
As they're doing appointments to public institutions.
As we are having ministers who are soldiers, as we are having soldiers who are in police. So it means the soldiers can leave the general court-martial if they want to dispense judicial authority, and then they are appointed ordinarily in the civilian courts. And some of the recommendations that the Supreme Court made was not that come up with a new name of your courts. It said if you really want to have military courts, then you can create a division of the military courts at the high court level. And that will take away the question of who is now appointing, because all judicial officers are under the courts of judicature. Because if it's division of the high court, it will be under the courts of judicature, and Article 129. That means that all the appointments now would be solely run by the Judicial Service Commission. And the state is not willing to do that. They are trying to cover it up and see how best they can bring back the general court-martial. And the purpose is, we know they are not thinking a lot, trying to rush things. I was looking at some clauses in the bill. They are bringing back the high command, adding in other who are supposed to be in the high command. And the exceptions they are talking of is of people who have been convicted. They don't talk of people who have died as per Schedule 3 of the original UPDF Act. But we have, I think, about 2 people who have passed on. So they are just importing the schedule back to the bill and adding in other people who can be part of the high command. So they have not well thought out on this bill. And we are thinking Parliament should do a lot of thinking, should do a lot of reading and borrowing from other democracies on what a military tribunal, a military court should be, and what capacity of offences it should try.
Okay, all right. Councillor Mulindwa, these particular amendments that we're talking about seek the risk of militarizing justice and also continuously infringing on the already hampered on human rights for Ugandans. And so it begs the question, how do we get to deal with this situation?
Yeah, I think militarizing the justice system will be a little bit of overstatement. Because when you look at the people who are the ones in the army stores, they have justice code of system they follow. And we, the civilians, also have a justice code of system we follow. Like I said before, the contention here is that if, as my colleague has said, if someone is a civilian and you have committed an offense with somebody who is an armed officer or somebody who is a person who security forces, the issue should be that where should you be tried? And he has brought some of very important solutions. He said they should create a division in the High Court, and that division should have persons who have the skill. For example, we can even have prosecutors who are skilled in that particular area, and they join the DPP. We could also have judges who are skilled in the particular area, but they are well monitored by the Judicial Service Commission and not the Commander-in-Chief. That is where now the injustice, that people feel that if there's an appointing authority, will be the one to direct or pull the tunes. So that's where the injustice is. So we all know that when we talk about justice in this world, it means fairness. So would that be fair if somebody is the one who is prosecuting you at the same time, or somebody having a complaint with you is the same person who's pulling the strings behind? That was just something which is a sham of a justice. The other thing that I feel that should really come out is that I feel in this legislature that they're trying to bring, they're over-legislating. There are some laws that are already existing, like the Firearms Act is already regulating civilians, if you're saying. They're just duplicating the law. So we are looking at issues to say, for example, now they are bringing issues like if you're caught with some senior attire, then even the Kaunda suit, they're now saying that if your Kaunda suit is, if it's green in color, should be for the UPDF. I mean, these are issues to do with the trademarks, you know. There's a law which governs that. Let the UPDF go, trademark that, but you're not going to go and smuggle these things and you say, we are bringing under the UPDF Act. Now we are seeing some people are wearing certain clothing, and then that clothing is, it has insignia. And now someone is saying, no, you should not have insignia, you know. So if it's a design of a cloth, like the way you're dressed, then people will wake up tomorrow and say, no, you're not supposed to dress like this because we want this. Now that is something that has to be, go through due process of the law. You cannot just wake up and say, we've now made the UPDF Act, you can't dress like this. You can't wear like this, or this is confusing. Yeah, you got to,
people are going to be wearing the yellow berets.
Yes, so it is, there must be some, when you're applying the law, I think one of the biggest challenges that we have in this country is when it comes to enforcement of the law. It is at that point where people apply the law against one side, and on the other side, the law does not apply to them. I think that is the biggest challenge we've had in this country.
Let me ask you, who do you feel is actually being targeted with these particular amendments proposed? I will not, myself, I will not put myself in the position to answer that question decisively, but I will give an opinion that from the way the public is looking at things, it's the way the law is enforced. So you don't need to be educated to see that tomorrow if I wear a certain color that aligns with the state and I put my insignia, no one will touch me. But if I'm wearing another color which is not in alignment with the state, then no one is going to touch you. So that's where the people are drawing the lines. So it's a challenge that the government is having. So if the government wants people to obey and respect the laws, enforcement must be across board. So those are some of the things that we feel that are being smuggled into the law, yet there are other laws that are already regulating. So we should say that if you're saying no one should wear any insignia, we're not coming from the armed forces, let it be so. You cannot wear a yellow one, you cannot wear a green one, you cannot wear a blue one, and only the army should have insignia. And that kind of thing should be put before, I think, is it the patents? Yes.
The patents.
Yes, the patents. That is, there's a full register there. You go and make your case, and then you register your patents. So those are some of the things that I see that cause injustice. People look at them as injustice.
All right. Yeah. Councillor Wanda, what are the elements of injustice that you are seeing through these proposed amendments?
The elements of injustice, one, I think when legislating and passing laws, we should look at laws that are to benefit even the future generation, not laws to solve the immediate problem. The immediate problem today is the opposition, but we all know that today's opposition can be tomorrow's ruling government. So to me, the injustice is, for as long as you're trying to pass a law to curb or to curtail a particular section of people to freely participate in the democracy of a country, then that's an injustice. And you're trying to use the law, one, because you have the numbers, so you believe that every law that you bring will pass. We've seen a host of laws before, which have been legislated for such a purpose, not only in this current government, but also immediately after independence in 1966, where we had an ordinance which was put forward by Gracie Vingira, and he was the first victim of that ordinance when he was deported to Karamoja. Recently, we had the Public Order and Management Act, and it was coming from a situation where the Constitutional Court had annulled sections of the Police Act, which were giving the IGP powers to allow any kind of demonstration or gatherings. And we saw the same being brought up in the Public Order and Management Act, and still the Constitutional Court struck it down. So we could see all the laws which were being brought. The intention is not to actually bring order or regulate public gatherings, but it was intended to curtail political opposition. And when one of their own became the opposition, the Right Honorable John Patrick Mama Mbabazi, he was stopped at the bridge in Jinja and was told, go back. As police, we have the rights to regulate what you're going to do, and we have not authorized you to go and have, I think he was going to have a consultation meeting towards his bid for presidency. So to me, an injustice is when we legislate to target a section of people and not legislating for the betterment of Uganda.
All right, speaking for the betterment of Uganda, you did make mention of our members of parliament who are in the hotspot right now. They must think, rethink, and they must be able to read in between the lines and make references, to other regional or even global references on this subject matter. This is where I want to bring in Mr. Mlongo on the subject matter of finding priorities for our country. Right now as we speak, of course, it feels like this is a very quick reaction and action by the government, courtesy of the Supreme Court ruling. And one of the questions that have been tabled is, what are the priorities of our country, especially in a time such as this when we are heading into elections around the corner in 2026? That's one. Two, what are the interests that are in this bill that the government is pushing it right now? It can wait. We have so many bills that are shelved and dusted, many years, 2 years, 5 years, 10 years, 20 years, mentioned quite a few. But all of a sudden, we see the Supreme Court ruling, then thereafter we do have an NRM caucus sitting that emphasizes by its chairperson that they must ensure that this bill is dealt with. And then thereafter, we see 100 million Ugandan shillings that is paid to members of parliament. And leader of opposition says that one of the purposes as to why this money is being wired to these accounts and these members of parliament is so that they can support the amendment of the UPDF Act 2025. And then here we are, a few weeks later, if we can rightly say, the bill is in parliament.
Well, it is interesting for members of the public and even the media to speculate a lot. And one of it is that this law has been hurried. Who determines the pace of hurry? Is it a night? Is it hours? Is it weeks? So what determines the hurry? And I could see this argument that it was hurried, they never even put enough thoughts. Who determines how much thoughts goes into something? Before you produce such a bill, you must look at a number of issues. You look at the history, look at the environment of this country, the history, look at the needs of the country, and national security is a priority. If we don't have matters of national security tackled first, nothing else can happen. It's like having a roof on your head before you can think of where to put which chair and which bedroom to sleep in. So national security is one fundamental thing. This law is intended to address issues that can threaten national security, where we can have courts to operate freely, we can have media houses to operate freely. National security first. Secondly, who determines priorities? In terms of the legislation processes, it is the executive that is required to provide the bills to the House. Of course, you can have private members' bills, but the resolute and key player in this is the executive. It is the government to generate bills to the House. So the executive is just doing its role. And to them, they have defined priorities which they don't have to go announcing on the roadside, that this is one of the things that must be done. And by the way, between January 30th and now, since the Supreme Court, there have been so many priorities that have been handled. The President has visited Karamoja, he has been to Chigezi as priorities before this bill. There have been other things done by government as priorities before this. This is not a priority at that time. It is a priority now. So in other words, what you call a priority is just normal business set by the government, scheduled by government to be done at this time. You asked me the second part was, if I hope I remember, the cure here is really to ensure that there is justice, there is fairness, particularly to the sector of the military and those who behave and act like the military. And as per guidance given by the Supreme Court, civilians will not be picked randomly. Nobody will just be picked randomly unless you do it. I am not a lawyer. I'm a lawmaker. I made the Constitution and I also legislated in Parliament. But I cannot behave as if I'm a land gentleman like these two gentlemen, because I'm not. If I want to behave like them, then I must go to the law school so that I can also behave and act like them in a manner that is required of them. But if I just want to pretend to be, then I should be dealt with accordingly. So, Madam Moderator, the issue of Parliament being cautioned to look at this with a sharp eye, indeed, yes, I agree with them. They should look at this with a lot of scrutiny. And I'm happy that my colleagues here should be able to meet the committee that is going to be meeting the members of the public and other experts to be able to provide even added guidance, added information, so that by the time the law is passed, it has contributions from all, particularly from the experts like them. So we should not have any worries. And to argue that we're targeting, first of all, elections. Elections are going to happen in 1 year to come. And that's the end of it. So will the law now stop operating? No. You cannot legislate for just a short term event. We legislate for posterity, for the generations to come. Secondly, do we target just some people? No. The law is very blind, by the way, and that's why the colleagues are very right. Those who legislated, in Kenya there was a gentleman who legislated against welfare in the prisons. And soon after that, he was taken to prison. And he suffered a lot in prison. You've cited cases of the Right Honorable former Prime Minister Mama Mbabazi and others. Yes, even me, I was in Parliament, we passed that law. And if I'm found on the wrong side of the law, definitely I'll have to face it. The issue, it is not about me or about them. It's about the country. It's about what we want to have in terms of stability, in terms of well-being of the nation, of the state, and of the country.
Okay. Councillor Wanda, Mr. Mulongo mentioned something and you gave him a side eye. randomly picking civilians, and I know that that was in reference to Dr. Kizza Besigye. First and foremost, what is the update on the case for Dr. Kizza Besigye, getting justice for him?
Where? In the general court martial or in civilian courts?
Both of them, because where we are seated, it is either or.
Yeah, you know, we last year in November when he was arrested, the prosecutor in the military court assured us that he was ready to proceed and prosecute the case. They had enough evidence against Dr. Kizza Besigye and his aide, and it was us, the lawyers, who were delaying them with technicalities, informing them or reminding them that they had no jurisdiction to try civilians, and also they did not have jurisdiction to try offenses which allegedly were committed outside of the country. They looked at that as technicalities, and they had said that even if within a week they were ready to prosecute. When he was recharged in Nakawa, of course with a completely different offense, but relating to the same facts in the 3 countries mentioned. To date, the state says they are still investigating. They inform us of how it's hard to gather evidence from offenses committed in different countries, which are not within the borders of Uganda. So that's one of the excuses that they are yet to complete the investigations. With regards to his liberty, as we are all aware, his first bail application was denied on grounds we don't believe were justified or were judiciously issued out. Unfortunately, we have no liberty to appeal on such applications, but we filed another application for bail. I think yesterday it was allocated to a judicial officer, and we're waiting for him to give us a date for hearing that application. And we are hoping that this time the judicial discretion will be exercised judiciously. But also, I think he will have reached a situation where bail is no longer a discretion, but it's the conditions that will be a discretion. Because our constitution says if you're incarcerated for 6 months in capital offenses, then you're entitled to mandatory bail. And what the court has to do is just set the terms of your bail, but they can no longer have the discretion to grant or not grant. So that's where we are. We are hoping we can have his liberty as soon as possible. Of course, we all know he's a politician of a PFF, where I'm a promoter, and some of our activities have been curtailed by his absence. Okay. Yes.
All right, let's also talk about since the constitutional ruling of trials of civilians in military courts being declared unlawful, that means that those that were in prisons at the time or who had cases at the time with the general court martial should be walking, scot-free, and then conversations also being on the table. Have you tried to, push for any compensation, and also what has been the response of government on these matters and cases?
The response of government has been very slow in regards to these cases. For the first time, we've seen the High Court trying to decline the authority they have of unlimited jurisdiction. If you file an application against the Attorney General in the criminal division, they will toss you and say, no, I think this one should be in the civil division of the High Court. If you file one in the High Court, they'll try and say, no, look, I think this one should be in the criminal division. So I think the only matter that we've had handled decisively is for my brother Aaron Kizza. It's the only application that has been filed and has been concluded. The rest of the applications that have been filed, both in the civil division and the criminal division of the High Court, are yet to be concluded, and majority are for people who had been charged. Their trials are not concluded. And since the 31st of January, they have not left prison. They have been on that long and not knowing when to come back to court remand. And also they have been kept there under expired warrants. That has been our argument in most of the matters, but we've seen the judicial officers reluctant to even, one, give parties the opportunity to address them on the issue, and we believe it was in anticipation or buying time for the executive to bring this particular bill. And even when we visit some of these point prison, what they be telling us that try and get me out here before they bring back the bill to Parliament. We know the intention might be that after passing the same bill into law, it becomes an act of Parliament, they just proceed with these cases as nothing happened. We want to remind all parties involved that it won't be business as usual, because at the time the Constitutional Court, the Supreme Court gave its judgment, so any more trials and holding of this poll became unconstitutional. So you cannot come back even after the law has been passed, because our laws do not act retrospective. So you cannot again continue trying people on the charges that they had after the Supreme Court declared such trials unconstitutional. So definitely, at the end of the day, our understanding, and we believe all parties involved in these trials should know and understand the same, is that these people should be acquitted, set free, and if you have cases against them, or you believe you still have cases against them in the new law, if they commit other offenses, then you can arrest them. Otherwise, as we are standing today, even if they transfer their files to the civil division, which is the criminal division of the High Court, we still believe that their trials would be unconstitutional, because they were founded on unconstitutionality. The charges were preferred by a body which should not ideally try civilians, and you can't carry on the mess to the normal courts. And it's been our argument from day one, but the state seems not to be agreeable to it. And the only person whom they have recharged is Dr. Kizza Besigye and Haji Abed Lutale. The rest of the people are just there in Luzira, Chitalia, with no hope of when they'll ever come to court.
Okay, that's a pity. Let's talk about the hierarchy restructuring, Council Munindo, where we get to see similarities to the civilian courts. For example, the unit court-martial to general court-martial having a similarity of Court of Appeal and the Supreme Court. Isn't this going to be weakening the functionality of the civilian court?
Yeah, I think for me the biggest takeaway in this is that the bill wants to give the general court-martial unlimited jurisdiction. Unlimited jurisdiction is given to the High Court by the Constitution. So this is going to be a point of contention when, even if that bill is passed. An act cannot give the general court-martial unlimited jurisdiction, where the Constitution already gave it to the High Court. So we are looking at a situation. The constitutional lawyers, of course, will be able to really challenge this. So the MPs should be smart about this. The Attorney General should be smart about this, and redesign this in a way that, whereas they now want to look like the structure of the civilian courts, but that provision where they're saying that it has unlimited jurisdiction and appellate jurisdiction is something that cannot pass the test of constitutionality. We are, although we are civilians, we are seeing that now some things are now being aligned to the fact that from the lowest level, which is the unit court, they're now putting what we call a lawyer. A lawyer is somebody who has gone to finish law school and maybe has not finished LDC. Then we're looking at divisional level, they're saying it should be an advocate. So that is also a plus we give them. Then at the general court-martial, they're having the equivalent of a judge. So that is also something which is positive, that people who are well engraved in principles of law are now going to sit at these other courts. That is not enough, because when it comes to judges, like you said, judges are governed by a law, okay? So this law governs the conduct. They are trained in a certain way. So if they talk about Judicial Service Commission, even if they are talking about their disciplining and things like that, it should be by Judicial Service Commission and not the Army or the Commander-in-Chief. So basically, these courts should change their should change the persons who are responsible to Judicial Service Commission than the structure. So there is some kind of change to that effect, but we are seeing that that in itself will not create justice, though it may give the court credibility, as I've pointed out here. But justice is something that cannot be touched, but can be felt. So what the courts will do in future in case the state continues towing that line is that kind of judgments, the kind of decisions that will come from there will determine how people will perceive these courts.
Council Wonder, now we speak futuristically. If this is actually signed and sealed, we would like to know, where do we draw the lines, what are the borders of justice and you know, the duties of the two courts then? The court-martial are being amended and the civilian courts in terms of power, in terms of mandate, and how would the two entities work in tandem?
I do not see the two courts working in tandem. Soldiers do not believe in civilian authority, though the Constitution and the UPDF Act demands that they be subject to civilian authority. And I think it's because of our history as a country, where we are coming from. But to me, the bill itself is trying to set the borderline of these are offenses that can only be tried by us. So you, as the Chief Justice and your courts, do not bother coming to these courts. The question which will always be there is, from the start, how are the prosecutors going to determine that these people should be here and these ones should be here? And this is where we need clarity. My brother gave examples of where we've had people using guns in committing offenses and they were being in civilian courts. We have people who have been accused of being ADF, and we all know ADF, his intention was to overthrow the government, and they were never brought to the General Court Martial. They were brought to the civilian courts, a bait that the case has never kicked off, which is very sad. That someone can be on pre-trial remand for close to 10 years. If any of you visits prisons today, you'll get to know that we have people who have been there. I met someone about a month ago who has been on pre-trial remand for 13 years. So, to me, the legislators should be clear-cut in passing this bill to a law and ensure that any offense that is already created for in the existing laws, the Firearms Act, the Terrorism Act, the Penal Code Act, the offenses should stay there. They should be tried by the civilian courts, and we shouldn't have that rift again between the military courts and the civilian courts. We know in hierarchy they have made modalities of appeal up to the Supreme Court, which we didn't have in the Act currently, which is good because we had a challenge. I think it was about last year, where the Supreme Court gave a judgment that was quite interesting. They were right in that judgment, because appeals are a creature of statute. So unless an appeal is created for, then you can't entertain it. They actually dismissed an appeal and ordered for a retry of that particular matter because there were irregularities in the first appeal. So they couldn't entertain the appeal on that PO. And the General Court Martial was poised with trying offences which have a maximum penalty of death. And then actually it was in contravention even of our constitution, because the constitution says that a penalty of death can only be confirmed by the Supreme Court. So where we have no appeal to that level, then it cannot confirm that sentence, but again, it can be executed because there is no mechanism of appeal. So I think that's the only change that is coming in this bill, but the rest to make sure we should have the civilian rule prevail over military rule. We are not a military state, though we see the military a lot in ordinary activities that should have police regulating law and order.
All right, Mr. Bulongo, the President, in response to the Supreme Court's ruling, said that the power belongs to the people. Some opposition members have been of the suggestion that perhaps we could have a kind of a referendum and involve the general public, the general civilian, and this decision making, so that they can be part of the voices directly on bills such as this one, and also streamlining to ensure that there is a just decision that encompasses everyone or is inclusive of everyone. What's your opinion on that?
The interpretation of Article 1, all powers belongs to the people. If you want just to read one part, the first part, and leave the rest, it is that power belongs to the people, but that power will be exercised in accordance with the provisions of the Constitution. So you can't just read one small part and leave the rest.
Yeah, but the President got only that one part, and it's what he stood grounds on to make his defense.
Yes, but you're asking me my opinion.
Yes.
I'm saying we should, even if he stated that way, but whatever exercise that we do with that power of the people, it should be through the rest of the provisions of the Constitution. And not that he was wrong, but the fact is that he knows and is conscious of the fact that if you're to roll into action what the people's power is supposed to be exercised, then it has to be through the provisions. Secondly, the Constitution provides for circumstances where we can have a plebiscite or a referendum. They're very clear. If this matter can fall under those provisions, then why not? We can have it. But as far as the government is concerned, this does not necessarily fall under that. And we are blowing a storm in a cup of tea over this issue. Court martials have existed before, but they met challenges and have been guided by the big pronouncement by the Supreme Court. And I think we're trying to right that by restructuring, ensuring the qualifications, appointment, and the process of these military courts to be aligned. And Counsel here, my young brother, has said it very well, that it is not true that it has not had such improvements as the public may want. The fact that you can appeal to civil courts, and the matter can even go up to the Supreme Court of civil courts, then definitely this is a fundamental difference. And I think that, yes, people will pronounce themselves on this law in accordance with the Constitution. They'll go through their legislators, their representatives. The public will be invited to make still added value to the law, including the experts like my colleagues here. So to me, we should not have any worries. The battleground of legal minds, politicians, philosophies, and so on, it has to be met in accordance with the law. And that's why the fears should not even arise as much. Of course, they're technical people, I respect them, but the issue is that me as a lawmaker and a politician and a leader, we should provide circumstances, conditions that are good for all parties to input into the law. Mm-hmm. If at the end of the day, Parliament throws out the bill, so be it. But if at the end of the day they pass it with such amendments, then so also be it. Because it is not a monopoly of one party to say this is right or this is wrong. There has to be somebody. Of course, my colleague was saying, the way
but the monopoly of the party is not in saying what is right or what is wrong. It is in the decision made.
No, yes, but now as in Parliament,
because if a party has majority in terms of vote, then that's already a decided vote.
As long as they're acting within the law.
And the law provides that they just need to vote.
And the law provides that democracy reigns. Democracy means majority. That's the whole unfortunate part of it. That if you go to Parliament, the majority carry the day. And if that's the condition, who are we to say no? Unless we go back to the drawing board and say it is minority voices which will prevail, then that will be a different thing. But as far as I know, the constitutionality of this matter is that all parties must be involved in accordance with the law, and in the Parliament, the majority will carry the day, and the law will be made.
All right. On that note, many a times we've seen the government lag on some policies, but yet catalyze and fast-track others. It begs the question, the qualitativeness of government in terms of decision-making and policy formulation for the development of our country.
Yeah, as I said, once the government is voted into power, they're given responsibility, including prioritizing. Depending on how they estimate what needs to be done and how quickly it should be done. We're not behind those corridors where we see things being reprioritized, but they do. Even if things go to cabinet, for example, there are a lot of hot arguments as to what should come first, what should precede the other, and so on. So really, I may not speak for every detail, but the fact is that there are circumstances that determine and is defined by human beings who are there in those offices that are holding those offices at the moment.
All right. The honourable members of Parliament are on a hot seat yesterday, and of course, they're going to be going through all these phases of debating the bill. But from where you're seated in your capacities, what are some of the recommendations and what are some of those areas you would want them to either rethink, revisit, or edit as far as this amendment bill is concerned? I'll start with you.
Yeah, the most important is, to me on my side, is that one, they should ensure as Parliament that there's no over-legislation in that bill, whereby the acts that cover some of the laws that they are proposing should be put in consideration. Secondly, when we talk about the composition of that court, giving unlimited restriction to the General Court Martial is going to be in conflict with the Constitution, but also we have to look at the fact that the plus that I give is that there is some kind of appeal to a civil court. And then what should be thirdly streamlined is that where there is a civilian who has committed an offense with the acting army officer, or that was an officer who was retired is now a civilian, that should be a question whereby the General Court Martial should come to High Court, make an application. That application to determine whether he should be tried along or they should be brought to this other court.
All right, thank you so much, Councillor Alan Mudindwa, for your inputs. Councillor Wanda.
My call to is, first of all, just for the record, the public were closed out. You see, they gave us, I think yesterday there was a notice in papers for us to give all our views in writing by today. That's by the Clerk of Parliament. It's quite unfair that people can be given a few hours to give their views on such an important matter. But we shall use such platforms to talk to them and tell them, to me, all the offenses that they have categorized as special cases, they should just delete them from that bill, let them remain in the acts we have of Parliament, and then the UPDF amendment bill should, in terms of offenses, let it be more on the discipline of officers, their punishment and everything. But we shouldn't have the normal criminal cases in there.
All right, Councillor Wanda. Ronald, thank you so much. And finally, Mr. Mlongo.
I think we have to obey to the strong winds of the Supreme Court when they provided guidelines as if we ever wanted to run a military court-martial, we should restructure, we should change the appointment processes, and so on, and we're doing exactly that. And the public has not been closed out in putting in their opinions. They've been given certain channels through which to provide those opinions, and we call upon everyone who is interested to support the process by inputting whatever opinion they have to have a law that is for all of us.
All right, thank you so much, Simon Molongo, an analyst there that has given us his 2 cents on the matter. Gentlemen, we're most grateful. And of course, as the media will be continuing to be the fourth estate, bringing you the observancy of the bill and how it's being treated through the lenses of honorable members of parliament. At the end of the day, you must consult with your member of parliament. Your member of parliament must consult with you as they are dealing with some of these bills. From the entire team of Morning at NTV, it's been a good discussion. Thank you so much for making time and being with us and sharing your 2 cents with us. Until we meet again tomorrow, have a good day and God bless you.